Yes, Kingara.
Thank you, Chair. We are grateful that the AG found it worth to come and share with us this burning issue affecting our Kenyans. Bana AG, we have traveled to countries which I don't want to mention, and we have noted that they had such issues, and they were able to create an avenue of renegotiating with those IPPs. Can you advise on such, sir?
Barongo, you have something to say? Or later?
Yes, my contribution would be that some of the IPPs have been willing to look at their rates, and I think as a committee we need to move with speed, see how much we can be able to get from them.
Maybe, AG, maybe something you can also guide us with. You know, the New Companies Act that requires a new companies being formed to list beneficial owners. So when the registrar of companies appeared before us, the registrar told us they are not able to work backwards. Now the companies in question here were formed before the new act, and they use that as the excuse not to dig further into getting us the information backwards. So probably maybe you can advise us if you think it is also an avenue that we can direct the registrar of companies to require all the companies that were registered prior to the New Companies Act to provide such information that is now being provided currently. So the other thing has been mentioned by one of the honorable members is this issue of acquiring the equipment once the term of an IPP has expired. I think I'm also shocked. You know, the office of the IG really should be fully involved when these things are being done, because really then no advices were in matters legal. So I'm sure, of course, when we are because our report will culminate into some amendments in the law to do things differently, even the way we procure IPPs, and I think such offices are critical. So what I wanted to understand is if now we have been paying capacity charge, for instance, for equipment, because that is the argument that we pay generators because nobody wants to keep their equipment when they are only producing for a fraction of the time when we have peak demand. So in essence, we are actually buying those equipment because when you look at the cost tabulation, there is a huge amount of money we pay for no generation at all. And they say it is sort of like insurance because they are keeping the generators there so that in the evening when we need more power, they can switch them on. So you end up paying even more than 3 times the actual cost in the market of those generators. Yet even after paying for those generators, when their term of contract has expired, it still remains the equipment. How? You know, one of the reasons why Kengen has been able to provide power cheaply is because they do not have that really issue of the capacity charge, because the equipment even for the thermos, they were bought a long time ago and they paid for themselves. And then after paying for themselves, they are still available and they are still in good condition. So we also feel that the billions and billions we've been paying for the equipment are in the name of the capacity charge. There is also a possibility that now by owning this equipment, because by the time the 20 years expire, this equipment can still run maybe for another 20 years or so. and it can go a long way in reducing the cost of energy. So there is really lots of issues that we think we'll also keep engaging you to see how we can, going forward, we can make use of your office to do the right thing for Kenyans.
Of the Companies Act, which provides that a foreign company shall not carry on business in Kenya unless it is registered under the Companies Act. And subsection 3 of it states that if a foreign company carries on business in Kenya in contravention of subsection 1, the company and each officer of the company who is in default commits an offense, and on conviction are each liable to a fine not exceeding 5 million Kenya shillings. So, and the reason I took the liberty to read this one out, Mr. Chairman, is because the Companies Act 2015 is the law in operation. It binds all those people who are doing business here in the name of companies, foreign and local. And I think it's not open to the registrar of companies to appear before Parliament to say that that was done in the past. No. That if there is any such company which has not provided names of beneficial owners, it is in violation of the applicable law. And this is, the applicable law is this 974 of the Companies Act. Because if we are to say, if we are to remain in that kind of mold, for instance, Mr. Chairman, one thing would be saying that we say we are doing certain things, I registered myself under the former constitution, and therefore I am not governed by the current constitution 2010. I mean, we can't have that kind of situation operating. So, Mr. Chairman, I think your committee should actually still invite the registrar of companies here. I direct her or him. I seem to maybe the way I used may have insinuated I know the gender of the registrar, to provide you with details. If not, report that those companies to the CID for possible prosecution. Because and this will be very easy. You have not provided the names of your beneficial owners. You are therefore in violation of the law. Take to court. Even if they go and, as happens, even if they plead not guilty in the first instance. But surely, at the end of the trial, they will still be found guilty. Because they will not have provided the names of the beneficial owners. That is what the current law requires. So that Mr. Chairman, I think it should be, and if that does not happen, Mr. Chairman, which is again tied to in a response to what the Vice Chair said, it is this committee's recommendation to recommend that the DCI or any other such investigative body, I think it should be the DCI, to investigate with a view to prosecuting, recommending the DPP for prosecution any such company that has not provided names of its beneficial owners. Because, Mr. Chairman, I believe that Parliament must have teeth, and this is the way to go. Directing that we have sought this information, we are told this company doesn't have beneficial owners, it is in violation of the law. Then it should the officers of the company and the company. In fact, the law is very clear. The officers, any officers of the company and the company are both liable on conviction to these penalties prescribed. So, Mr. Chairman, I think I would. That would be my reaction to answer what the Vice Chair, or did you say acting Vice Chair? Member for Uzalendo. and sought, because I thought it was an important point, because I think this is a way to go to so as to unravel some of these mysteries. People cannot continue exploiting the public, and then when you want to know who they are, they are nowhere. In any event, there is a principle in companies law known as, and it's a very old one, known as the lifting of the veil. Well, I'm sure members will understand, our Muslim brothers and sisters who may be here. They like covering themselves with a veil. So you lift that veil, you see the person. So I think Parliament is in that unique space to actually lift this veil to know who are these people. And like you said, Mr. Chairman, and I know you are right, I agree with you. Many of these people are not the foreigners. They are local. When I did investigate the issue of which I told you about Mobitelea, in fact, a member who was a member of my party came complaining that we were pouring soil on his food when we went to lift the veil. So it is true, Mr. Chairman, and I think you're on the right track. I would really want to encourage this committee to go to the bottom of this. Let's know who these are. And I want to also confirm to this committee that these agreements, which have been said to be incapable of being abrogated, were not negotiated with the assistance of the Office of the Attorney General. KPLC, and I think whoever else involved there, they went direct and negotiated those things. So the State Law Office doesn't have copies of those agreements. So I think, Mr. Chairman, that's why I think it's important. It's just been confirmed to me by the officer who is with me that those agreements were never presented to the Office of the Attorney General for input and advice. Of course, that is not the case now. Today, you don't have to recommend that. Today, that is not the case. And the current arrangement, all legal agreements by whatever ministries, MDAs, agencies, they must get the input of the Office of the Attorney General, so that at least we can save the country the ignominy of always having to pay dearly for that which could have been avoided. We will not be able to, maybe we will get to the situation that Honorable Kingara and Honorable Mwafrika were saying of pay and buy and pay, or pay and take and pay. I think if there had been that input, we will not be in this kind of situation. And the reason, the Chairman, I'm encouraging you, is because I believe, honestly, the reason why the State Law Office was never involved in the negotiations leading to those agreements is because, had the office been involved, I'm sure we will not be where we are. So, I really would want to, encourage the committee to please make as many recommendations as possible, because I believe it's for the benefit of the country. Yeah.
Perfect. So you will have first the honourable member introduce himself. Looks like Mose, you have something to say. Then we close the meeting. We have
supplementary. Do you think you have power now to record for those agreements? To call for those agreements in the office?
We don't even know where they are. And we can't call for that which we have not been asked. We are not a party. We have not been made party to those. But of course, what will happen is, if there were to be a suit against either KPLC or the ministry, that's when they will start coming. They will run to our office, and they run with sometimes, a lot of times, with very little information. When they are questioned, they give you a bit of it. By the time the judge is making a decision, you have not received full information, and you can almost guess that Honorable Gimose, yourself a non lawyer, obviously government will lose, and that's how we see every day government losing cases, because the people who have the information never want to provide it to the state law office in good time, and the reason being, they know. There are some things you can look at and say, obviously this one ulijifunga hapa, kwa hivyo sasa tuambie vile, why don't you begin to negotiate, even as just the same way that Mr. Chairman, you suggested to the ministry and the KPLC, begin negotiations, and you can see they are willing to do that, because they know wenyewe walijifunga kitambo. But Mr. Chairman, as I said, I want to repeat, please insist on weekly update of those negotiations. Otherwise, itaendelea. I'm telling you, I've known about this matter for more than 20 years. And every time the answer is, no, it will be too expensive to terminate. But nobody has ever come up with the figures of how much it is that we would pay. Perhaps actually what we have paid over the last maybe 5 years might have been enough. And maybe, as is it the Honorable Elisha Wu suggested, maybe we should have taken over the equipment. The direction that you are moving, Mr. Chairman.
Chair.
Thank you very much. Yes, Mheshimiwa, you are the last one.
Yeah, thank you, Chair, and thank you, the AG. My name is Geoffrey Mulanya, the MP for Nambale, and also a lawyer by profession, and I'm really surprised. I've just come in late to hear the frustrations that you are giving us, because you are the principal legal advisor to the state. And Chair, I don't know what you discussed here, but I believe that if the position is as the AG has put it, is it possible through the AG that we can have the ministry produce these agreements, bring them forward, so that we see the officers who signed? If we are saying that we want to cancel, then we say that if they bypass the principal legal advice of the state, then they individually let them be made culpable to pay. That's my submission, Chair.
All right, thank you. So part of those, you want to say something?
Yeah, just to tell the member for Nambale that we can't ask for the agreements ourselves. But earlier on, I think we had agreed with the chairman, this committee, as parliament, you must get the agreement. You must insist to be shown those agreements, then so that even you make informed decisions. And as the member has suggested, those found to have bound government in unconscionable contracts be meant to take responsibility. Yeah, Mr. Chairman.
You introduce yourself.
Thank you, Chair. My name is Victor Koech Mandazi, MP for Chepalongo.
Just to put that to perspective, Mheshimiwa. So right now, like the AG said, the situation is that, of course, all contracts, the AG's office is now involved for anything that is new. But we're talking about those contracts that were not following that route. For whatever reason they were not, really that's now another subject. But I think now things are in a better perspective. And some of those contracts we are talking about, like the power purchase agreements, we are in possession of those power purchase agreements for all those companies now. So, and that's how we've been able to see the differences in the kind of costings that and tariffs that they've been given. So, AG, you've been very, very useful to us. I want to thank you in a very, very special way. We'll continue engaging you before we conclude this exercise on matters that we need more clarity. And I want to promise you on behalf of the committee, we'll get to the bottom of it. Okay.
Thank you, Chairman and members.
So we are adjourned, members.